litigations, and I will identify the characteristics of each state. Number 4, you will learn the concept of standing. Number 5, there are various methods of alternative dispute resolutions, and there are potential advantage of using these alternative dispute resolution. I will tell you. Number 6, you will learn the difference between arbitration and mediation. Number 7, I will explain how online dispute resolutions is used to solve small claim dispute. Number 8, I will teach you the hybrid form, current hybrid form of alternate dispute resolutions. Okay, introduction. This chapter overview the role of dispute resolutions in business planning. Dispute resolution options is very, very important part of business planning and the business strategy. Therefore, business dispute resolution option is required a serious cost-benefit analysis. Serious cost-benefit analysis is required for dispute resolutions. And this chapter introduces the process of using the civil litigation to resolve the dispute. In order to operate your business, and in order to enforce and protect your legal right, you need the process. And you need to know the process to resolve this dispute. And this chapter introduces the method, various methods, many types of methods of the alternate dispute resolutions. Okay, first type of dispute resolution is civil litigations. Civil litigation describe a dispute resolution process. During the civil litigation stage, the both parties, such as the plaintiff and defendant party and their attorney, will argue their view of civil controversies or argue their view of non-criminal controversies in a court of law. The probabilities of business organizations becoming involved in litigation have increased sharply in recent years. The U.S. Department of Statistics estimated that over 40 million lawsuits are filed every year in the United States of America, and the total number of registered lawyers exceed 1 million attorneys. More than 90% of cases, the vast majority of cases are heard in the state court, and less than 10% of cases are heard in the federal court. 90%, more than 90% cases are state cases. Less than 10% of cases, controversies are federal cases. Pre-lawsuit stage. One of the important pre-lawsuit stage is a pre-litigation settlement negotiations. Pre-litigation settlement negotiation is very, very important, because more than 95% of the lawsuit filed are settled prior to the completion of a litigation process. More than 95% of lawsuits are solved as a settlement. If the issues are relative simple, this settlement negotiation is a very, very cost-effective method to resolve the controversies fairly and very, very quickly. Also, this settlement negotiation can minimize publicity. It means that decide in the private. There are two parties to the lawsuit: plaintiff party and the defendant party. Plaintiff party is a party who start the lawsuit by filing a complaint with the clerk of the court, foreign court, against the defendant. Defendant is the party who is sued from the plaintiff in a civil lawsuit. The defendant may be called respondent. Some textbooks use respondent instead of a defendant. Same meaning. Defendant, respondent, same meaning. Getting into the court. In the last class, previous class, I already told you the requirement of getting into the court. Subject matter jurisdiction, personal matter jurisdiction, and this chapter added the standing to sue. In order to get some people into the foreign court, it requires that the plaintiff must have the standing capacity to sue. Next, the court, the foreign court, have the power to exercise subject matter jurisdiction and personal matter jurisdictions. Okay? Therefore, the foreign court need all these three requirements in order to get the defendant into the court. The standing. Standing is defined as a legal right that the plaintiff has to bring a claim in the foreign court. The plaintiff who have a standing capacity must involve the actual cases, actual controversies, and to have a standing capacity, plaintiff must have a personal stake in the outcome of resolutions, must have a personal interest in the outcome of the resolutions. In order for one party to maintain a lawsuit against another party, the party who is asserting the claim against the defendant, that is called as a plaintiff. The plaintiff must have the following three elements to have a standing capacity to sue. First element, the plaintiff must have suffered an injury in fact for the standing capacity. Second element, the plaintiff must have suffered the damages. The damage is direct. That damage must be concrete. That damage must be individualized. Third element, the plaintiff must be able to articulate what legal remedy are existing to compensate for my damages, compensate for my injuries. Subject matter jurisdictions. Subject matter jurisdiction is a court, so power to hear the particular type of dispute. Subject matter jurisdiction divided into two types of jurisdictions, general jurisdictions and limited jurisdictions. Trial court has general jurisdictions. Appellate court and specific court has a limited jurisdiction, such as probate court, traffic court, federal court, bankruptcy court, immigration court, tax court, etc. First, matter jurisdictions. Personal jurisdiction is the court, is the power over the specific party to the cases. In order to have a personal jurisdiction, the court must have a power to enforce bringing the person into the foreign court through the summonses and services of process. For in order to have a personal jurisdiction over the out-of-state residents, out-of-state dependent. In that cases, each state long-arm statute are used for non-residential parties based on the minimum contact with the plaintiff party's state. Minimum contacts is a requirement of the Amendment 4 of U.S. Constitution, the due process of law. There are 7 procedural stages: pleading stages, pre-trial motion stages, discovery stages, pre-trial conference stages, trial stages, post-trial motions, and final stage is appeal stage. The litigation is formally started with the plaintiff's filing of pleadings in the court with the clerk of the court. Okay? Litigation is started with the filing the pleadings and the summonses. Pleading and summonses is the initial requirement for starting the litigations. First stage, pleading stage. If the informal attempts, such as the arbitration and mediation and settlement, are failed, in that cases, the plaintiff, the damaged party, started the lawsuit by filing a complaint and arranges for services of defendant with the summonses. Therefore, 2 documents are required: complaint document and summons document. Summon is a formal notice that is given to the defendant. The summons provided that the lawsuit has been filed against you is a summon document. Answer: after the complaint and summons are filed in the court, the defendant must answer the complaint. If no answer is filed by the defendant, the court, the judge, has the power to enter the default judgment in favor of the plaintiff. Therefore, the defendant answer must respond to each paragraph of the plaintiff's complaint in order to narrow the scope of the issues in the controversies. Okay? Pleading stage consists of the final complaint and summons and the defendant answer. Counterclaim and cross-claim. Counterclaim is a claim that is filed in addition to the answer when the defendant believes that the plaintiff has caused her damages arising out of the same set of facts as articulated in the plaintiff's complaint. Cross claim is a claim that is filed when the defendant believes that a third party is also fully or partially liable for my damages that plaintiff has suffered. Therefore, that third party must be embarked as an indispensable party in the trial. Is a cross claim. Discovery stage. Discovery stage is a formal legal process. During the discovery stage, both parties, defendant and plaintiff, must engage in variety of activities in order to gather information and discover the facts of the cases from the other party, and discover the facts of the cases from the witness prior to the trial. The purpose of a discovery is to help establish the merit of the claims and narrow the issues for the trial. Discovery serves several functions. Functions to prevent surprise in the litigations, in front of the judge, in front of the jury, and functions, discovery functions to allow the parties to thoroughly prepare for the trial, and the discovery functions to preserve key evidence, and functions to save court time, and functions to promote settlement of the cases. The major formal discoveries are as follows: depositions, interrogatories, request for the production of a document, request for the physical examination, request for the mental examination of the party. Deposition. Minimum deposition fee is the $30,000. If one party wanted to have a deposition, that party must pay the minimum $3,000. Very, very high cost to have but one deposition. The deposition is a sworn, defined as a sworn, out of court testimony, that is given by the party, that is given by the witness. Deposition is used to gather information as a part of a discovery process, and that deposition's outcome will be used at the trial. At the deposition, the person must be appear at a specific time and must be appear at a specific places, such as the plaintiff's attorney room or dependent attorney room. And that person must give a sworn testimony under the earth. Usually, the court report or the interpreter present in order to record that scene. Court report. Write the statement and submit that statement into the court. Sometimes witness can be compelled by the court. Subpoena is an order. You must get into that place. Is the judge's order. If you do not get into the certain court, you will be jailed. You will be received the penalty. Subpoena. Interrogatories. Interrogatories is the second method of discovery. Interrogatory is a written request that is submitted by the one party to the other party. Interrogators may require documents to clarify the matters or fact of the cases. That interrogatories must be answered and returned within a set time period. Normally 9 days or 7 days. The defendant must answer and submit the interrogatory documents within the 7 days or 9 days. Another discovery method is a request for production of documents. Request for production of documents will ask the opposing party to produce certain documents that is relating to the cases. Typically, these requests include the bank statement, financial records, contract, agreement between the two parties, etc. The opposing party must produce these documents within a given time period, normally within 10 days. And the opposing party must give a reason as to why the document cannot be produced. Another discovery method is a request for a physical examination and request for the mental examinations. If the physical or mental condition of a party are at question, at issue, a defendant may require the opposite party to see a doctor and submit to the physical examination and submit to the mental examination. These usually happens in the cases where the action is a personal injury, car accident cases. If we strike the car, the plaintiff request you too much money. Oh, my neck is broken. In that cases, you must request for the physical examination. Doctor's X-ray result of the plaintiff's damaged party is the examination required in order to decrease the cost, insurance cost, and compensate the cost, damage cost. Dismissals and pre-trial judgment. A pre-trial motion is a motion a party make to try to cancel, to avoid, to divorce all of the lawsuit or part of the lawsuit prior to trial. There are two types of pre-trial motions. Motion for judgment on the pleadings and motion for summary judgment. Motion for judgment on the pleadings are the party's request to the judge to rule in my favor based on the pleadings on file without accepting any evidences. These are requests when the outcome of the cases are only based on the judge's interpretation of the law, not final fact. There is no need to find of the fact. This claim is only based on the interpretation of the law. In that case, the party apply the motion for judgment on the pleadings. A party may file this motion for judgment on the pleadings on the basis that no answer has been filed. Defendant did not answer, or the pleading discovered that there is no material issues of the fact to be resolved. Material means important. There is no important issues of the fact to be resolved. In that case, the party filed a motion for judgment on the pleadings. Another pre-trial judgment, another type of pre-trial judgment is a motion for summary judgment. Motion for summary judgment is a motion that asserts that there are no factual disputes to be decided by the jury. The judge, in that case, the judge can apply only the proper law to the undisputed facts and decide the cases without the jury. It means that the judge has a power to find the fact, to find the law without the jury. That is referred as a bench trial. Okay? These motions are supported by affidavits, supported by documents, supported by deposition testimony. Table 4-2 illustrated shows the various type of motions that is used during litigations. There are various type of motions used during litigation, such as follows. motion for dismisses, motion for summary judgment, motion to compare discovery, motion to dismiss for mistrial, motion for judgment as a matter of law, and motion for judgment as a matter of fact. Please read this table 4-2 and your home. Okay, pre-trial conference. Pre-trial conference is a meeting between the attorneys for both parties. Both parties' attorneys are gathered in the judge's room. Okay? A meeting between the attorneys for parties and the judges several weeks prior to the trial. Primary reason to have the pre-trial conference is to encourage settlement. The judge told the both parties' attorney, oh, settle. Settle is the best for the plaintiff part and for the defendant part. 95% of all cases are settled before trial. During the pre-trial conferences, okay, more than 95% of all cases are settled during the pre-trial conference. Second reason of the pre-trial conference is to identify the real issues in this field and the planning the future courses of the trial. If the case cannot be settled during the pre-trial conferences, the parties will eventually go to trial. The trial generally takes place in front of the judge, as a judge is a law finder, and in front of the jury. Jury is a fact finder. There are two functions, fact finder and law finder. Fact finder is a jury's job. Law finder is a judge's job. Under the bench trial, the judge will act as a fact finder and the finder of law. Okay. There are 7 stages of trial. Jury selection stages. Jury selection is referred as a voir dire, Latin word. Voir dire is a legal terminology, very, very unfamiliar with the common people, including you, the students. Second stage is opening the statement. At the opening statement, there is an overview of essential facts from the two parties. Third stage, presentation of evidence. Fourth stage, directed verdict. Fifth stage, closing argument. Sixth stage, judge's instruction to the jury. Final stage, jury's verdict stage. Jury selection. Jury selection is called as a voir dire and the opening statement. Trial begins with the process of asking the potential jurors questions to reveal any prejudice in order to select the jury. The questioning process for selecting the jury is known as a voir dire. Voir means the truth in the Latin word. Dire means the speak in the Latin word. Voir dire is the questioning of prospective jurors by the judge or by the attorney in the court. After the jury is selected during the voir dire processes, the attorney present their theory of the cases and attorney present what they wanted to prove to the jury in the opening statement at the opening stages. Testimony stages. After the opening statement, the plaintiff's attorney then asks the questions. That is known as a direct examination. Ask the question of the witness as a direct examination. The defendant, after the direct examination, the defendant attorney may then conduct the cross-examination of the same witness. Therefore, direct examination, cross-examination, cross-examination are exchanged during the testimony, witness testimony. Submission of evidence stage. Each side also used is a witness to introduce the relevant evidence in order to authenticate the documents, to verify the physical evidence, or to provide the expert testimony. That expert testimony will be accompanied by the chart or accompanied by the graph. That testimony will be shown and represented to the jury. Closing argument. Once the testimony or evidence are presented to the jury, the attorneys sum up, collected the cases, and try to convince the jury that their vision, their version of the case is more compelling. My opposing part is for. I'm not in for. Okay? This is known as a closing argument. Instruction to the jury. The judge has a power to instruct the jury because jury do not know the law. Jury does not graduate the law school. Therefore, the judge instructs to the jury. Okay? The judge then charged the jury by giving the jury instructions on how to walk through the process of coming to the factual decisions. The judge will also inform the jury that the standard of proof in a civil case is a preponderance of evidence. There are two levels of evidence. Preponderance of evidence and the reasonable doubt of evidence. In the criminal cases, the plaintiff must submit the evidence. That evidence must be beyond the substantial doubt. But in a civil cases, preponderance evidence. Preponderance means more than 50% percentage. Beyond the reasonable doubt is more than 95% of the fact. Deliberations. After receiving the charge from the judge, the jurors move to a private room and engage in the deliberations until they reach the jury's verdict. Although the jury is permitted to send the questions to the judge, the jurors are alone, individual persons, in their individual deliberations. The jury, each jury has power to vote, to submit one vote. The verdict is decided based on the majority of the vote. Verdict. The jury returns the decision. That is, return the verdict. Normally, there are 7 or 9 juries in the grand jury. However, if the jury cannot agree on the verdict, this is known as a hung jury. Hung jury means cannot decide the verdict. Pro and contra are same, both. Hung jury. And the litigant must start the process over. The rules for civil litigations frequently do not require unanimous verdict. Therefore, hung jury are rare in a commercial business dispute. Post-trial motions and appeal. The losing party can file a post-trial motions to trial and convince the original judge that the verdict is default. Verdict is pro. The original verdict is wrong. In that cases, the appellate court engage in the judicial review to decide whether any errors in the trial court were committed during the trial, and also have the appellate court has the power to reverse the decision of the trial court, and appellate court has a power to modify the decision of the trial court. Correcting the judgment. Correcting means the enforcing the judgment. Although the prevailing party may have received the court judgment stating that you are entitled to recover your damages, to compensate the money damages from the dependent. However, correcting the judgment, enforcing the judgment, sometimes very, very difficult. Because the losing party filed bankruptcy. In that cases, the plaintiff cannot receive any money from the dependent. Okay? Even if the plaintiff wins the damages award, there is no guarantee he or she can collect the damage money damages from the dependent, especially if the dependent assets are tied up in the non-record form, such as the real estate. Real estate means the property. Your residential home is a real property. Okay? Or the dependent assets are tied in the form of the exempt from the claim of creditor through the bankruptcy filing. In that cases, you cannot collect the money damages from the dependent. Okay, another type of dispute resolution is alternative dispute resolutions. Alternative dispute resolution is a process during the alternative dispute process. Disputes are resolved outside of the court system. Disputes are resolved outside of the court system through the help of the neutral third party. Why do we, or why do the campaign, the business, choose the alternative dispute resolutions? Because alternative dispute resolutions can reduce the cost, can reduce the time, and can preserve the business relationship and preserve the privacy. There are a lot of appropriate methods of certain types of the cases, such as family law dispute, real estate dispute between the neighbors, and high-tech dispute, or trade secret dispute. In that cases, alternate dispute resolution is the best for these controversies. Arbitration. Alternative dispute arbitration has many type of methods, such as arbitration, mediation, online method. Okay? Arbitration. In arbitration, the parties submit their dispute to one or more arbitrators, and the party present the evidences and present the limited witness testimony, and then a decision is made. That decision can be a binding decision or non-binding decision. That depends on the agreement of the both parties. There are three big types of arbitrations: voluntary arbitration, contractual arbitration, legally mandated arbitrations. Voluntary arbitration divided into types: binding voluntary arbitration or non-binding arbitration. All contractual arbitration are legally binding, legally enforced by the court. third type of arbitration is a legally mandated arbitration. Legally mandated arbitration is a non-binding. Losing party has a power as a legal right to appeal to the appellate court. Mediations. Mediation is a method of settling the dispute outside of the court by use the service of a neutral third party, by helping, with helping the neutral third party. Neutral third party is normally retired judge. Retired judge play a role as a neutral third party. This neutral third party act as a communicating agent between the both parties, between the plaintiff and defendant, and this neutral third party help them in negotiating the settlement. The advantage of mediation are as follows. There are few rules. Customized process. Parties control result. Therefore, win-win case will be happen. This advantage of mediation is it costs mediation fees. There's no sanctions, no deadlines. Therefore, mediation period is extended long and long. Okay? Mediation is becoming increasing common as a cost-efficient form, because mediation is a relatively informal and mediation does not require much time or does not require prepare as the arbitrations. Expert evaluations. Expert evaluation is a method of alternate dispute resolutions where an independent expert act as a neutral fact finder. Expert evaluation is particularly very useful for the parties who is involved in a business dispute, and the issues are somewhat very complex, very complicated, and the issues are related to the intricacies of a certain industry or professions. Expert evaluation by an independent expert who recommend the settlement is very popular alternative resolutions method. Hybrid form of alternative dispute resolutions. Sometimes hybrid form of alternative dispute resolution is known as known as mediation and arbitration. Both parties first submit to the mediation for a fixed period of time, perhaps 2 days. If the mediation fails, the process then moves to binding arbitrations. Okay, final slide. Online dispute resolution is another type of dispute resolution options. online dispute resolution. Use internet to resolve the dispute. The rules for online dispute resolutions are being developed currently. And these rules for online dispute resolution may become a code of conduct. Please refer to the www.cyber, etc.